Live stream audio test 1 2.
It's now 2 o'clock, so the inquiry is resumed. Does anybody want to draw anything to my attention?
Yes, so just very briefly, on the submissions we just heard from Mr. Winstone before we broke, in those submissions, Mr. Winstone, as you heard, made representations about various other heritage assets, outside of the two that have been identified by the principal parties, and made criticisms of the archaeological investigations of the site. I haven't had the chance to run this past Mr. Sutton, as you might imagine, sir, and these are all matters that are agreed in the Statement of Common Ground. Unless you give me an indication, sir, that you would need to hear evidence on those other points, I wouldn't envisage calling Mr. Sutton again or doing anything in writing on that. But obviously, sir, if there are unanswered questions on those points, I obviously need an opportunity to get Mr. Sutton to look at them. So it's really if you think that there is an insufficiency of evidence on those other heritage matters Mr. Winston raised, then I obviously need to deal with that.
Right. Okay. Right. Can I have a think on that, and I can come back to you on that tomorrow morning. All right. At the minute, my initial reaction is no, and we'll turn that particular document away. But I'll just have a think on that and come back to you tomorrow. Okay. Right, is there anything else? All right, so we heard the council's planning evidence this morning, so now opportunity for the appellant's planning evidence. Mr. Garvey, would you please call your witness?
Yes, thank you, sir. Just to introduce you to the inquiry, your name is Guy Wakefield. You remember the RTPI and hold a BA Honours degree in Town and Country Planning, and are a partner at Ridge & Partners, based in their offices in Cheltenham.
That's correct.
I'm going to take your qualifications and experience as read. So I'm also going to take the entirety of the proof as read, because we've heard a lot of evidence by this point. So it's only 5 brief residual matters that I want to address. Just prior to me getting to that, can you just give your experience of when you first got involved with this site?
When the scheme was first being considered, when the site was first being considered by Beechcroft in terms of its potential suitability for a housing development.
Thank you. So the 5 issues I want to talk about, the first one is the emerging local plan. It's agreed in the Statement of Common Ground that only very limited weight can be afforded to the emerging local plan. I think it was being suggested to Mr. Stevenson in re-examination, well, given its only very limited weight, what's its relevance to this appeal? Or at least can you tell us why is the emerging local plan relevant to this appeal?
Okay, so there's 2 parts to the answer. Briefly, those 2 parts are effectively that, firstly, it goes to the weight to be considered in the context of the harm arising from the development, and the second issue is the council's reliance upon it in terms of addressing the 5-year housing land supply position. So dealing with each of those matters in turn. Firstly, in terms of it providing evidence as to how significant this district is in terms of it being so severely constrained, both the choices for the future document and the preferred options document do contain both factual information, e.g. the map that was turned to in Mr. Stevens' evidence. that is fact in terms of how much of the district is constrained by Greenbelt, floodplain and AOMB. And there's obviously numerous paragraphs in there that you've already been referred to, sir, in terms of how that plays out in terms of the ability for various towns and settlements to grow. And the second part is that effectively it's through the preferred options document, it identifies that in order to meet a housing requirement figure, notably that is below the actual figure that the council should be working towards, it is planning to go into the green belt. Now, I say, sir, that particular issue shows the direction of travel that the plan is heading towards, in the sense that it is proposing to allocate somewhere in the region of about 4,000 units in the green belt. In my experience, sir, no council would propose development in the green belt, bearing in mind the need to identify exceptional circumstances. No council would propose that quantum of development or development in the green belt per se, unless there was an absolute necessity to do so. So whilst the document can only be afforded very limited weight, it is a material consideration that does show the direction of travel that the plan is heading toward, and effectively does highlight just how constrained this district is, which then effectively has an impact in terms of how you calibrate the harm arising from the development in terms of the adverse impacts that you may or may not identify, and how much weight should be given to those harms when carrying out the planning balancer. So that's the first part of the answer. In terms of the council's reliance upon it to address their 5-year housing land supply, which is the only remedy that they've advanced so far as part of the inquiry, as I understand it. Firstly, it is a document that can only be given very limited weight, which was agreed between the parties. And for that reason, sir, I would strongly be suggesting that it cannot be relied upon at this stage to be said to be helping to address the 5-year housing land supply in the near future. In fact, in my proof of evidence, I say that it will be a considerable period of time before the document is to be adopted, when it would then be able to be relied upon as an action or a remedy to solve the 5-year housing land supply position. But at this stage, as I say, very limited weight in the statement of common ground. So that's the first part of that particular part of the answer. The council, in terms of their history of plan preparation, give me no confidence that the adoption will happen anytime sooner. The council say in their LDS that effectively it could be within 19 months, 18 months from now. I find nothing in terms of the council's history in terms of preparing plans to suggest that that will be the case. I think the core strategy itself took 5 years to adopt. The sites allocation plan, I think, took 5 years to adopt. And indeed, to get from just the issues and options paper, i.e. choices for the future, to the preferred options document has taken the council 2 years. So how they could then suggest that it would only be 18 months from now until adoption, I severely question that proposition. Indeed, when you then consider the greenbelt issues that are having to be addressed as part of the plan's preparation, that will naturally be a significant issue that will have to be grappled with and no doubt objected to and questioned by those involved in the plan's preparation, both in terms of objectors, supporters, etc., etc. So that would also, in my mind, raise significant query about the confidence I'd have in terms of the plan being adopted quickly. And then there's also the issue of unmet need arising from Bristol. How is that going to be tackled? The plan so far, in terms of the preferred options document, is silent on that particular point. There's nothing to suggest that it will consider that. But clearly, as Mr. Tiley refers to in his proof of evidence, the needs of Bristol with latest data, latest and standard methodology, does increase the pressure and requirement on Bristol to find more homes, and therefore neighbouring authorities will have to take some of that pressure, you would have thought. So again, silent on that particular point. And then, as I said, whilst the plan is at preferred option stage, it does still need to find a further 2,800 homes before it could satisfy itself that it is actually meeting its requirement, let alone Bristol's. So bringing that all together, sir, I would strongly question whether or not there is a short, potentially medium-term solution to identify and addressing the 5-year housing land supply proposition or shortfall.
Thank you. Just dealing with those 2 points, sticking with this theme of emerging local plan, there was the constrained aspect, it's an evidence base that speaks to that. Your second point is, well, the local planning authority relying on that as a remedy to the 5-year housing land supply.
Correct.
I think you said it's the only remedy. I think in fairness, the local planning authority have also said, well, there's CS32 and CS31, there's the flexibility inbuilt into the development plan, and that they can get 25 units outside of small villages and 50 outside of larger and 75. Given that we, as we sit here, we are only aware of 2 such sites that the local planning authority relied upon, how credible do you find that assertion that the 5-year housing land supply will be remedied by the flexibility afforded in policy?
I don't find that very credible at all. The plan has been adopted now since 2012 and then re-adopted in 2017. It's therefore been adopted and in play for a significant period of time. To then rely on effectively 2 sites providing somewhere in the region of 75 units and then using that as an argument to say that it would go on to effectively resolve a significant shortfall in the 5-year housing land supply is not credible at all.
Thank you. That's the first theme, the emerging local plan. The next theme, I want to turn up the Hallam Land judgment. And this is about the relevance of the 5-year supply debate. So the Hallam Land you'll find at core document G44.
I have that.
Thank you. There's 2 parts to the judgment I want to look at. The first is paragraph 51, which we've already looked at up to date in the inquiry.
Did you say 51?
Yes, please. Have you got that?
Yep, I have that.
So we'll just read 51, and we won't read it out because we've already looked at it again before, but I want to look at another paragraph as well in the judgment.
Yes, I've read that.
And then the next part I want you to go to in the judgment is paragraph 82.
Yes, I have that.
So there, the court said, well, here, well, actually, let's look 81. Clearly, a determination whether or not there is a shortfall in the 5-year housing land supply in any particular case is a key issue. Further, if there is, then the tilted balance for the purpose of paragraph 14 of the framework comes into play. Here, it was common ground that there was such a shortfall. Pausing there, that's obviously the same scenario we found ourselves in this appeal. And then the court went on to say, that being so, I have the greatest difficulty in seeing how an overall planning judgment thereafter could properly be made without having at least some appreciation of the extent of the shortfall. That is not to say that the extent of the shortfall will itself be a key consideration. It may or may not be. That is itself a planning judgment to be assessed in light of the various policies and other relevant considerations. But it will ordinarily be a relevant and material consideration requiring to be evaluated. In the next paragraph, just the opening, the reason is obvious and involves no excessive legalism at all. The extent, be it relatively large or relatively small, of any such shortfall will bear directly on the weight to be given to the benefits or disbenefits of the proposed development. So it's being suggested, it was suggested Mr. Tyler yesterday, what's the point in the debate? I want to understand how is it relevant in your view, this debate that we've been having about 5-year supply, and has it informed any planning judgment you've reached?
It is relevant, it's absolutely relevant, and insofar that the greater the shortfall, the greater the weight to the benefits, and the less weight that's given to the disbenefits or harms arising from the development.
Thank you. And we've canvassed the other issues that are addressed in paragraph 51 about what the council are doing about it. I think we've covered that sufficiently with Mr. Tyler that I need not cover that with you unless there's anything you've got a burning desire to say on in respect to that.
No, I don't.
Thank you. That's the second theme. Let's go on to the third theme, benefits. You helpfully set out at near the end of your proof of evidence a table on benefits and adverse impacts at the bottom of page 26.
I have that.
Yeah. We'll leave adverse impacts because I think that Sean, you'll be taken up on that. But on the benefits, where we've got to, on 5-year housing land supply and affordable housing, we've agreed substantial on both with Mr Stevenson. On support to local services and facilities and promoting a healthy, inclusive and safe community, you give that a moderate benefit. Anything you'd like to say on that?
Nothing to add from what's said there.
Thank you. Environment, conserving, enhancing biodiversity and providing net gains on site. Let's deal with this point now. Obviously, there's the metric of 44.13.
Yes.
Yeah, and just for the avoidance of doubt, because it's being suggested the council only provided that recently. When did you provide the metric to the local planning authority?
We provided the metric through an email on the 6th of May.
Yeah.
So that was prior to the submission of proofs of evidence.
Yeah, and that's how you reference it in your proof of evidence. It's being suggested, well, given that this is an outline proposal, the council, and we can't have certainty as to the extent of BNG, the council can't have regard to that 44.13. What's your view?
Well, firstly, most councils that I'm working with at the moment on various applications, etc., are actually carrying out an assessment of the BNG calculation, where one is being required by the council. For example, where a council, whether it be at the moment, the one that springs to mind is Oxford City Council, where they are effectively encouraging us to find 10% biodiversity net gain, they will then carry out the calculation as to whether or not the figures are correct, even though those applications are outlined. So somewhat surprised by the council's position on that. And secondly, given, whilst they refer to the illustrative plan and question that in terms of its role in the outline application, clearly the illustrative plan does show significant areas of open space that will make a contribution towards the 44%. Those areas of open space are in fact required in order to address the impacts on bats and bat habitat, and therefore put that together with the actual number of units being sought here, i.e. up to 62 units, it follows, and I believe the inspector should be able to have confidence from the fact that those open space areas that are making a significant contribution to the 44% will be required in any reserve matters application to follow on from this. And therefore, I believe that based on the calculations themselves as provided, not challenged, coupled with the point I've just made around the actual illustrative layout, I believe that the inspectors should be able to actually take confidence from what's being put forward by the appellant on this issue.
Thank you. Just testing this thread that the council say, well, in principle you can get something, but we're not going to close our mind to the percentage. There will undoubtedly be sites that are so constrained that the most they might be able to get, hypothetically, is 0.1% BNG. No matter what you do, that's all you can get. And then there are sites like this where potentially there's the 44.13. Does it make sense that you wouldn't distinguish between them if they're both at outline stage?
No, it doesn't make sense at all.
Thank you. Anything else you want to say on BNG?
No.
You give limited benefit to surface water drainage. Anything that you want to bring to the inspector's attention in that respect?
I won't spend too long on it, as we suggest only limited weight, but so if I can just give you a few references from the flood risk assessment that form part of the application.
Well, hold on. That's core document C13.
Yes, that's correct.
Yeah.
So I'll just read these out, sir, for your benefit rather than asking you to take up the document. So paragraph 5.15, and just actually stepping back a bit, obviously, sir, you'll be aware that this is a heavily constrained district relevant to flooding, and indeed, as you'll see in the flood risk assessment, there is some history of flooding within Churchill itself. So just bearing that in mind, paragraph 5.1.5 says, second sentence, by introducing a managed drainage system for the site, these overland flows will be reduced significantly, as will the flows leading off-site to the west. And then it says, small point in 6.1.8, from the SUDS hierarchy, the most favourable method is to discharge greenfield runoff into the watercourse via vegetated ponds to provide silt inception, pollution reduction, amenity, varied habitats and enhanced biodiversity. And then moving on to my second reference, 6.1.13, as the current 1 in 100 year greenfield runoff rate is 14.4 litres per second and the proposed runoff rate is 5.9 litres per second, the overall runoff rate from the site will be significantly reduced from the existing greenfield runoff rate, especially in rarer, in brackets, and important, more intense events. Third reference, 6.2.7, states this strategy will bring a significant reduction in existing flood risk to the properties west of the site and reduce nuisance overland flows. And then finally, sir, 6.5.5 and 6.5.6, I'll read 6.5.6. The consequence of the development will be to reduce the frequency and scale of natural flood risk west of the development. Combine all of those points and references I've just given you, I believe that the development will provide a benefit relevant to off-site flooding, and to that extent I've given it limited weight.
Thank you very much. And then finally you address economic, but again I think we've agreed significant on that this morning. So unless there's anything else you want to say on benefits, we can move to the next issue.
Yes, please do.
Thank you. And happily, we've actually done one of the issues there when we talked about BNG. So moving on to the final issue, I'd like to talk to you about some of the points that have been raised by some of the local residents. There's been obviously a myriad of points that are addressed in transport and drainage and whatnot. There's 2 points that I'd like to ask you about. The first is about employment opportunities.
Yes.
It's obviously been agreed in the statement of common ground with the local planning authority that there's good access to service facilities and employment. Anything else you'd like to bring to the inspector's attention in that respect?
Only a helpful reference to add to the statement of common ground is the note or document submitted by Oliver Turbeville, a resident that spoke in opposition the other day. Mr. Turbeville's note does identify in the second half of the first page and overleaf as well that there are numerous vacancies available within the area. Numerous vacancies, I haven't totaled them all together, but I would suggest there are about 40 plus vacancies within Churchill and the immediate surroundings, suggesting that there are numerous employment opportunities to be taken up by the development.
Thank you. And then the final point is it's being suggested that there's no capacity at the GP surgery. To what extent, if at all, have you investigated that point, and what, if anything, have you found? Yes,
I did do a quick search recently as to whether or not there is capacity, and I went on to the Mendip Vale Medical Group website, and indeed on that it does say...
Well, just before you... That's the GP surgery?
Correct.
And the proximity of that to the site?
It's probably about a mile and a bit from the site,
right.
Off the top of my head.
Right. And what did that say?
That basically says, under the title, How to Register, it says, we have an open list and welcome requests for registration from patients living or moving to the practice area.
And help me, is there any request for any NHS contributions through the Section 106 agreement?
No.
And is there any evidence that there's a lack of capacity for medical provision?
No, there isn't.
Thank you very much. Is there anything else you'd like to bring to the inspector's attention?
Only that there is capacity at the local schools on that issue as well.
Yes, thank you. Any other points on any other matters?
No, thank you.
Thank you. If you wait there, you'll be asked some questions.
Are you ready and comfortable to be cross-examined?
Yes, sir.
Yeah.
Thank you very much. Right, good afternoon, Mr. Wakefield. Now, Beechcroft, as I understand it, they advertise themselves as one of the UK's leading retirement developers, building quality homes for the over 55. Is that correct?
That's Beechcroft Developments Limited. This is Beechcroft Land Limited.
Oh, different. This is Beechcroft Land, right. So what do Beechcroft Land do then?
So they are effectively promoters.
Promoters.
So they find sites and promote them through the planning system and then sell them to house builders at the end of the process.
Good. That's helpful. So they're promoters, and when you first got involved with them, was it at the point they had secured a sufficient interest to make it worthwhile their being a promoter?
Sorry, say that again?
When you first became involved in this scheme, was it because Beechcroft had acquired an interest in the land that made it worth their while to promote it?
No, I believe it was before that. It was before they effectively signed up to any option agreement with the landowners. They were just looking at it afresh.
Yes. So it would be fair to say that Beechcroft acquired their interest upon your advice as a planning consultant.
Not just my advice, but the advice of other consultants as well. Normally the process with Beechcroft is that they will employ or commission or seek advice from a number of consultants relevant to any given site and be informed by their advice. So at the same time that we were asked to look and advise, Mr. Cook, the landscape architect, was, I believe Mr. Farmer was as well, as was Mr. Sutton as well.
So when was that?
That was before any option agreement was signed, just from memory.
Well, when was it? Was it December?
I can't remember the exact date, to be fair.
Well, I know when these people were instructed, because more often than not it tells me in their documents. I just want to know when you were instructed. When did you give your planning advice that led to Beechcroft deciding to take an interest in the land? When?
I don't know the date. I honestly don't know the date.
So who was the lead consultant?
Well, it was myself with input from those other consultants that I've mentioned.
Yeah. So did you instruct Mr. Cook and Mr. Sutton?
Yes, I recommended to Mr. Fletcher, who's here today, that he commission the services of Mr. Cook and Mr. Sutton, and I believe Mr. Farmer, to give some initial advice on the suitability of the site for development.
Yes, and when you gave that advice, had you already advised on the planning merits of the site?
No.
Right. I see. So you were approached and you said, well, if you're going to use me, use these people too.
Yes.
So, out of interest then, if you were advising Beechcroft before they acquired interest in the land, you would have been aware, wouldn't you, at the time, that there is a policy, CS32, that would have provided a potentially trouble-free route if they could overcome the various bullet points that the policy expresses. At least it would have been possible, wouldn't it, to have come forward with a theoretically policy compliance scheme, because you could have come up with a scheme for 25 units adjacent to settlement boundary, couldn't you?
That is one possibility that was available to us. I think what actually happened was that effectively we were given, let's say, a red line boundary plan, and the heritage and landscape witnesses were asked to comment on the appropriateness of the site, full stop, and also the amount of development that could be accommodated on the site as well.
Sure. But had it been your advice, the developers could have made an entirely policy compliant proposal, at least in principle, couldn't they? Because they could have stuck 25 units adjacent to the settlement boundary. Sure, they'd have had to do with landscape and heritage issues, and who knows whether they could have done or not. But the particular conflict with the plan that you identify could have been approached in that way, couldn't it?
That was one option available to us.
Why didn't you do that? Because you see, the reason I ask it is this. Something has been said about the likelihood of the flexibility allowance bearing fruit, and we'll come to that in a minute. But one obvious observation in this case is, had you sought to take advantage of the flexibility allowance, you could have done.
We could have done, but as I said, we were given a plan that showed the site in its entirety, and the consultants, I believe by Beechcroft were asked to consider the amount of development that could be accommodated in the site, knowing what the conflict with the plan was at that time, in the context that obviously at that time we didn't consider that the council did have a five-year housing land supply. We were aware of the conflict that was arising, and that's the proposal before us today.
Yeah, so you were aware of the conflict at the time, you decided to make a non-policy compliant proposal.
Well, that's effectively what we're acknowledging is the case.
Well,
Yeah.
at the time, you recognised the conflict, but you cracked on anyway. Is that fair?
We certainly were aware, yes.
Yeah, good. You were aware. Thank you. Now, at the time, were you aware of the Wardle-Armstrong sensitivity study?
I'm not I can't remember, honestly, if Mr. Cook referenced that in his note advising on the site suitability.
No. But if we just turn up, call document E5, please, which is the sensitivity study, and we go to map 3 at the end. You'd agree with me as a matter of fact, wouldn't you, that if one asks the question, has the council identified less sensitive sites around the edge of Churchill, that is adjoining the settlement boundary, the answer is that they have, several of them.
As I said, I cannot remember if Mr. Cook referred to this particular document.
That wasn't the question. Would you like
in
to
his
answer the
note.
question?
Can you repeat the question,
Yes,
please?
the question was, it's right, isn't it, that if you look at this document, there are identified several sites of a lower sensitivity than that which you have decided to promote around the edge of Churchill.
Taking that at face value, that being the case, those sites were not on the table at the time. They were not available to my client. That was not what was being considered by the client at that time. My client was considering the suitability of this site, not whether or not there were any alternative sites that may or may not be better. Indeed, we don't even know whether or not those sites that you say may or may not be better are actually available, by whether or not the landowner is willing to dispose of those sites.
You said they weren't available. Did you mean to say we didn't know whether
We
they
didn't
were?
know whether I...
Right,
Okay.
so when you say they weren't available, what you meant to say was we didn't know whether they were.
Well, the client would
Well, no, hang on.
basically take...
I want to know what you know. Be careful. Answer these questions carefully, please. First of all, did you know whether they were available or not?
I'm going to intervene because I asked Mr. Stevenson, is the council advancing the case that there are better alternative sites? He said there's no requirement in policy, and that's no part of his case. So why are we going down this avenue when your own witness conceded
Well,
at that point?
Because your case advanced through this witness a little while ago and to Mr. Stevenson this morning was that we are so jolly well constrained in North Somerset that we're going to have to go into the Greenbelt. What I'm seeking to understand is if one wants to grow Churchill, is there a problem? And I'm not going to take this much further, but I'm entitled to ask the questions in the light of your line of questioning, both your witness and my witness.
I think the document that you've pulled up is a landscape sensitivity assessment. Just bear that in mind when you put in questions to
And I'm
the
not going to go
witness.
very much further, so there's no need to. But I think it's a fair question to put to the witness. I just want to see where it takes us. I'm not
Yeah.
going to go much further.
Yeah, but I'll just warn you with your questioning as to what that document may or
Yes.
may not show.
Yes, of course. So what I'd better do is put it to you very precisely. What this document shows is sensitivity of landscape to housing development. Did you appreciate that?
I appreciate that. That is what the purpose of the document is.
Yes.
It is giving it's looking at one consideration of many in terms of when one assesses the suitability of any given site. It is one consideration of many.
It is. It's landscape sensitivity in relation to housing developments. Having got that clear, if I could just return to the question I asked you, and then we're going to move on happily. Question. did your clients check the availability of these other sites at the time? If the answer is you don't know, just say so.
I don't know.
Fair enough, we can move on. Good. Thank you. Now, moving on. We know how it was you came to be involved, why you chose a non-policy compliant number. Dealt with sensitivity. Fine. We can, yeah. Let's choose a different topic, shall we? Could you please go to page 11 of your evidence? I'm going to talk about policy CS5 now and also touch upon CS32 to the extent it deals with landscaping. Now, 412, Mr. Cook's proof also concludes that the local landscape character and distinctiveness will be protected and enhanced, and so on and so forth, such that it meets the first part of policy CS5 and policies DM10 and DM32. And then at 413, given the policy wording, Mr. Cook concludes that the proposals do not conflict with the relevant development plan policies. Now, as I understood Mr. Cook's evidence, and you'll recall the exchange we had about how one interprets CS5, I understood his evidence to be, until he gave his answers to me, that he had formed the view the correct way to interpret policy CS5 is to consider impact on the landscape as a resource, but not its visual impact. Is that your view?
Yes, it is.
Right. Could you please help me with this then? Have you looked at appeal decisions in the core documents where policy CS5 has been in issue?
Yes, I have looked at those appeal decisions.
There is no indication, is there, that policy CS5 has ever been interpreted by any other inspector, or any inspector I should say, to be concerned solely with the impact of proposal on landscape per se, rather than on visual amenity?
No, there's not, but there's no indication that any appellant has sought to distinguish between the two either.
That is true, which may be because it's not a good idea, but let us ask why that may be so. You see, if you've got a landscape policy such as CS5, what you're trying to do, amongst other things, is ensure that development is not going to cause harm to visual amenity. That is an object, isn't it, of landscape policy?
Yes, it is, and we've not tried to avoid that particular matter or give consideration to it. In fact, Mr. Cook does conclude that there would be visual impact arising from this development, and I include that within the planning balance.
You do. But if we've just agreed, as we have done, that one of the objects of landscape policy is to avoid harm to landscape visual amenity, it would be a strange thing, wouldn't it, to read a landscape policy so as to exclude the effects of impact on visual amenity. That would not be a very useful landscape policy, would it?
Well, that's what the policy says. So we can only carry out an assessment based on the wording of the policy, and that's what we've effectively done. We've not chosen to ignore that particular consideration. We say it is a material consideration to be included within the planning balance, which I've duly done.
Yeah.
Whether or not that particular aspect of landscape impact is or isn't included within the policy itself, as we've said, doesn't materially change things in terms of the outcome. It is included within the planning balance, and ultimately we've conceded that the proposal is contrary to the development plan when read as a whole. So,
well, let's just see that very briefly. First of all, there is a difference, isn't there, between conflict with policy and another material consideration, which may or may not indicate permission should be granted. Because if something is contrary to policy, that is your starting point, you have the section 38.6 test, it is a matter of some importance, isn't it? If a scheme is contrary to development plan policy. Yes?
To some extent that's true, but obviously we have to bear in mind that the policies are there to advise upon the impacts. So you have to identify the impacts first. We've done that, we've duly done that, and for that reason I say that it wouldn't make a material difference to the outcome in terms of the planning balance as to whether or not there is reference to a policy in there. There is clearly reference to visual impacts. There is reference to the fact and acknowledgement that there is visual harm arising from this development, included within the planning balance.
Well, Mr. Wakefield, the inspector's heard your answer, and I don't think it's going to serve anybody any great good by prolonging this exchange. We can make submissions on the proper interpretation of CS5. The short point, though, is you don't repeat the suggestion in respect of DM10 that it should be applied in the same way that you've applied CS5, do you?
Let me just turn that up.
Please do.
Well, as I said, I don't believe that Mr. Cook or myself are saying that visual impact is included within that policy either.
Well, yeah, there's a slight difference. Let's just pursue this point a brief moment or two. You take the trouble to deal with CS5, or rather Mr. Cook does, you don't, you just agree with him. But neither you nor Mr. Cook say, do you, that DM10 is not concerned with the visual impact of a proposal. Straightforward yes or no will do. You don't, do you?
I don't know.
No, and nor does Mr. Cook, does he?
From memory, I don't think he does.
No.
But I'm not 100% sure.
So if we remind ourselves what you say at page 26 of your evidence under paragraph 7 to 8, rather table 1.
Sorry, what was that reference?
It's page 26 of Mr. Wakefield's evidence in table 1. So we note that applying DM10 to take account of visual impact, since there is moderate harm to the landscape, there would be conflict with DM10, wouldn't there? It's page 26, table 1, row headed visual harm to landscape, result moderate. It's Mr. Wakefield's proof. So we can agree that there would be conflict with DM10 on that basis.
Oh, sorry, can you put the question to me again?
Yeah,
I was just finding
sure.
the reference.
One of the things you do not do, we've agreed, is say that DM10 excludes the visual impact of a proposal. You've agreed you didn't say that, and Mr. Cook doesn't say that. Therefore, applying the scale of impact recorded under table 1, it would be right to say, wouldn't it, that there is conflict between this proposal and policy DM10.
I don't agree with that. Whilst I'm looking at Mr. Cook's proof of evidence at the moment, whilst certainly in the section I'm reading, section 10, he doesn't implicitly say that DM10 does not include visual impact. It is implied that that is the case by assessing the policy as it's worded in terms of his assessment of that policy.
Well, you see, reading 413, given the policy wording, Mr. Cook concludes that the proposals do not conflict with the relevant development plan policies. 413 of Mr. Wakefield's proof, so page 11.
Yeah.
Given the policy wording, Mr. Cook concludes that the proposals do not conflict with the relevant development plan policies, the first part of policy CS5 and policy CS32, DM10 and DM32, as those policies refer to protecting and enhancing landscape character. So that's what's said, yeah? Now, help me with this. Let us just go to CS5 first of all. So that's core document A1, page 130. No, it's not 130, I think it's 40. Page 40, that's right, CS5.
I have it.
you have it?
I do.
Right. Tell me the words that you rely upon to come to the construction of that policy that you do.
Can I interject, sir? I don't enjoy intervening during cross-examination, but I'm wondering, where does this actually go that's going to help you? Because you'll recall, I said, does this interpretation point, is it academic? And Mr. Stevenson agreed in respect to both policy CS5 and DM10, it's academic in the context of this appeal, whether you find visual harm, whether that leads to a consequent conflict with this policy, given on either view, there is still conflict with the development plan as a whole. On either view, that visual harm still is a material consideration that weighs against the development proposal. You'll recall that was unequivocal, the agreement, that these are academic points. So I'm just wondering, where is this going? Is this a point that we really need to spend inquiry time dealing with an academic point?
Well, the first point is, when I re-examined Mr. Stevenson, he did explain that it wasn't academic. And the second point is this, that if it's Malone and Friends' submission, that it doesn't matter how many policies are offended, I find that surprising, but so if you're content that you've heard enough on this topic, I'm happy to move on because I can make submissions. But I was interested to understand how Mr. Wakefield came to the view that he expressed, because on the face of it, Mr. Cook had made that judgment, but then he gave it to Mr. Wakefield as a sort of hospital pass. So I'm interested to understand how Mr. Wakefield came to his conclusion.
I don't know how to close on this point, because I want to say it's common ground, it's academic, and in re-examination, what that would cause is the policy material academic? No, we don't suggest the policy is this particular interpretation point. Do you factor virtual visual harm into a consequent conflict with the policy? That was agreed to be academic. So I'm wondering, where does this really take us?
Well, I'm not sure.
How do I close when I've got unequivocal answers from the witness?
Well, you haven't. Well, I'm ever so sorry, but you haven't got an unequivocal answer. You have an answer that was correct in re-examination. That's the first point. Second point is how you close is up to you. But the third point is I think I am entitled to ask this witness how he came to form a view that he doesn't actually form in his evidence, but which Mr. Cook does, but then handed back to Mr. Wakefield. So if you're not finding this helpful, we can move on.
It's not helping me greatly.
Well, then, sir, thank you for the indication, and we'll move on. Thank you, sir. But as to how Malone and Friend closes, I do maintain what Mr. Stevenson said, and I'll make my submissions accordingly. Right, so we've aired that one.
Okay.
Right. Right, thank you. We're feeling chastised, I think. I'll move the microphone closer. So, CS5 dealt with, DM10 dealt with, DM11 next. One of the things I hope we can agree is you spend a little time in your evidence dealing with policy DM11, don't you?
I do, because it wasn't included in the reason for refusal, the putative reason for the refusal put forward by the council.
Yes, you dealt with policy DM11 because you recognised its material, didn't you? Otherwise you wouldn't have bothered, would you? As you say, it wasn't in the reason for refusal, but you deal with it. And you deal with it, it seems to me, but you'll tell me if I'm wrong, in order to avoid it negating the operation of the tilted balance. If we go to page 30 of your evidence and we look at the first bullet point on that page and we read that bullet point, that is the first bullet point that's indicated by a bullet. As I read what you said there, you sought to avoid the first limb of paragraph 11D of the framework being triggered by, amongst other things, harm to the setting of the AONB. That's what you dealt with there, isn't it?
Yes, we say there's no harm to the setting of the AOMB and therefore that particular part is not triggered.
Yeah. Now you did that, and I won't take you to all the other references to DM11 in your evidence, because, to repeat the point, you recognise, don't you, that it is material to consider the question of whether there would be harm to the settings of the AONB? You recognise that as material?
Yes, that is, if we're in the setting, which we agree we are, it's relevant to then consider whether or not there is material harm to the setting of the AONB.
Yes, and you would agree that that is a matter to which you defer to Mr Cook on?
That's correct, to establish whether or
And
not
the
there's material
appellant defers to Mr Etchells. If the inspector concludes there is harm to the setting of the AONB, then that harm is to be considered alongside any harm to the significance of the two heritage assets, designated heritage assets, that are considered by this appeal, or rather being talked about in the course of this appeal. That's right, isn't it?
It depends on the context and what harm is being alleged. We've had the discussion around whether or not that harm is arising from views out of the AONB, or whether views towards the AONB.
Yes. Look, I don't want to muck about. Let's just take this in a nice straightforward way. We've agreed that impact on the setting of the AONB is a material consideration, because otherwise you wouldn't have bothered writing about it. The point is this: if the inspector concludes there is harm to setting, whether it's viewed from the appeal site towards the AONB or vice versa, the point I've asked you to deal with, please, is it should be placed in the balance, shouldn't it, alongside the impact to designated heritage assets. That's right, isn't it?
In the overall tilted planning balance, can I qualify?
In the consideration of paragraph 1 of the tilted balance, yes.
No, that's not correct.
Right. Well, I did give my learned friend a copy of the Monk Hill decision over lunch. I wasn't going to take you there. Could I deal with it in this way? I mean, are you familiar with the Monk Hill decision?
I haven't read it recently, but I'm aware of it.
Well, then I'll put this question to you in simple terms, and then if you, depending on your answer, in fact, whatever your answer, I'm going to move on, because I can make submissions, but I just want to understand your understanding of how the tilted balance operates. Where there is alleged to be conflict with any of the footnote 7 subject matters.
I'm going to close this off. So I hate having to intervene, but my learned friend is trying to suggest an A and B objection under footnote 7 of the framework. His witness conceded the only clear reason that they rely upon is heritage, and A and B is not a reason for refusal in and of itself. So if my learned friend is trying to backtrack and introduce A and B as being a clear reason for refusal, it flies in the face of his witness, and none of these points were re-examined on. I say my learned friend can't go there. He doesn't have the evidence to support this case.
Well, Mr. Etchells has plenty to say about it.
Doesn't make any point about the application of paragraph 11 of the framework and A1B policy.
Well,
Mr. Stevens is the witness who dealt with that. He agreed the only clear reason for refusal the council rely upon is heritage.
Well, I think Mr. Stevenson did say, actually, that he relied upon what Mr. Etchells said in relation to the AONB. What I am putting is this, that first of all, your witness himself deals with this topic at this paragraph of his evidence. So, to argue that I can't ask your witness about it seems to me to be a bit of a stretch. Secondly, what I've said, what I'm asking your witness to deal with, is the impact on the AONB goes into the balance that one must consider under paragraph I of subparagraph D of paragraph 11. That's all I've asked him.
Which is contrary to the council's case, because the council are not suggesting A1B is a potential trigger to disengage the tilted balance. It's absolutely clear that that's what was agreed, and it's entirely consistent with the council's proof. I had a whole chapter of my cross-examination I was going to go into. Didn't need to, because it was agreed. So for the council to try and backtrack on that, I say, and I hate having to do this.
Well, then
it shouldn't be for me to have to require my friend to be disciplined.
I think from what I've heard and the common ground specifically, that I think we're straying into territory that perhaps shouldn't be trodden with.
Well,
this
then let me
particular
put it a slightly different way, so
witness.
then see if we can stop there. It having been conceded that, well, I think it is conceded, it is conceded, isn't it, that the question of whether there is harm to the setting of the AONB is a material consideration. That's right, isn't it?
In principle,
Whether or not there's harm to the AONB is a material consideration.
Yes.
It is.
So let us assume that the inspector is right in law to exclude that matter from the tilted balance. Let's just proceed on that basis. And let's assume that my learned friend's approach doesn't lead him into choppy waters. Taking it in the simple way,
I don't think he's doing
well,
that.
sometimes you have to be careful what you advise a decision maker, but never mind. Let's just treat it as an ordinary material consideration. It would be relevant, wouldn't it, that there is harm to the setting of the AONB, whether or not it forms part of the application of the tilted balance. That's right, isn't it?
Sorry, just repeat that.
Yes, I'll repeat it a third time. The fact that there is harm to the setting of the AONB, either views towards or views from, is going to be a material consideration in the determination of this appeal, whether or not it forms a consideration in the application of paragraph 11D. That is right, isn't it?
It is a material consideration in considering whether or not there is harm arising from views in or around, but one has to distinguish between the two to form a judgment on whether or not paragraph 11DI applies or otherwise.
Yeah. Now then, on that basis, we know that it came as something of a surprise to the appellant that there is a paragraph within the PPG which deals with the question of whether or not views towards the AONB are to be regarded as material. But you would concede, wouldn't you, before I have to take you there, that views towards the AONB are in fact material when one comes to consider impact on setting.
You have to consider, as we've said, it is material to consider whether or not there is harm in views towards the AONB. But that is not the same as then triggering paragraph 11DI.
I think we've gone past that. The inspector gave me a very firm gypsy's warning and I decided to take heed of it and I've packed it in. But I've moved on to the material consideration point. So from a material consideration point of view, you'd agree with me, wouldn't you?
That views towards the AONB is a material consideration?
Yes.
Yes, I would.
Thank you. Or rather, views the harm to the setting of the AONB viewed from the appeal site is a material consideration, to be precise.
If the inspector concludes that there is material harm on views towards the AONB, that is a material consideration.
Right.
If harm does arise in those views towards.
Thank you very much.
That
Well,
does not
I'll
trigger
make
me.
it clear that I shan't pursue the D1 point, so I'll pursue it as a material consideration instead. And then my learned friends' submissions will be what they are. Now, moving on, so that's dealt with DM11. BNG next. Now, biodiversity net gain is calculated having regard to a number of things. I'll just see if we can achieve some measure of agreement on what they are. First of all, one has to consider the baseline quality of what one is dealing with.
Yes, I understand that that is the starting point.
Yes, and the quality of the baseline environment can make quite a big difference to the calculation of BNG. That's right, isn't it?
I'm not a specialist on the calculation of BNG.
So don't
that
you
would have
know?
been that would have been a point for Mr. Farmer, I think.
Well, it would be if Mr. Farmer had produced evidence. that
Well,
spoke-
he did provide the calculation.
Yeah,
And
he did, but that was after you'd set out your case in your pre-inquiry statement, so we didn't have a witness.
yes, but you did have that.
Well,
before
yeah,
the
all right, if
5
we're
or
going to go
6
down that line, go to your statement of case, please. D1. and just take me to the part which says the appellant will rely upon biodiversity net gain as a material consideration in support of its proposals.
It's not in there.
It's not, is it?
Um,
So
it's
when the local planning authority, when the local planning authority, well, he answered the question.
I was going to carry on, but
Were you? Oh,
I
go on.
don't. I mean, it's not in there. It's a fact. It's not in there. The statement of case is principally dealing with potential reasons for refusal, etc., and critical points in that respect. I didn't feel that we needed to deal with BNG in terms of the statement of case. There was no allegation from the council that we wouldn't be able to achieve a BNG score of, let's say, 10%. There's no policy indicating that we had to, and therefore I didn't feel that it was a key feature that had to be included in the statement of case. Secondly, as we've already discussed, the council had the BNG calculations some 5-6 weeks ago now. If there was a problem with it, i.e. if the council didn't want to deal with it, they could have advised so at that time, or indeed at the start of this inquiry. They chose not to. I really don't see why, therefore, the council would take umbrage with the calculation being put forward. You don't want to consider it. You don't want to consider it. The inspector's got record of that. But ultimately, why you would resist it?
Well, the reason is this, really. First of all, you'd agree, wouldn't you, that the inquiry's procedure rules require you, when you set out your pre-inquiry statement, to provide full particulars of the case that you will advance at an inquiry. A failure to do so can amount to unreasonable conduct incurring an award of costs, can't it?
It can do, but as I said, it wasn't one of the key issues that had been raised by the council at that time, or was on the table, so to speak, in terms of the comments that we'd had back from the council. It wasn't therefore something that there was any allegation of policy conflict with. I don't think there's any indication within the policy that one must achieve a score of X, and therefore, as I've already explained, it wasn't a critical issue that I felt had to be included in the statement of case. I don't think that's unreasonable.
Right. Second point, the council has in fact conceded that it is possible to secure biodiversity net gain on this site, hasn't it?
It has.
Thirdly, that being so, the calculation of BNG is obviously, isn't it, intimately related to the scheme that eventually comes forward. Because, for example, if one's going to have, I don't know, numbers of trees, length of hedgerow, fed into the calculation, which of course is what happens, then one needs to know the length of hedgerow, number of trees, etc., that one is dealing with. That's right, isn't it?
Yes, and we've made those calculations based on the illustrative layout, which takes those into consideration.
The next point, it being agreed that one needs to know the number of hedgerow units, trees, that sort of thing, as well as the baseline state of the environment we're dealing with, and for that to be agreed. Unless a particular proposal is secured by condition, it's impossible, isn't it, to conclude reasonably that the amount of BNG that one is dealing with is the amount that is claimed. It might be 44.2%, it might not, but the reality is until we have a scheme that allows that calculation to be carried out, we can sensibly agree to there being BNG net gain. That's what we've done. But one can't sensibly say it's 44.2%. That's right, isn't it?
I don't think it would be our case that we are going to absolutely, and the inspector should be absolutely confident that we are going to hit 44.13%. But what I do say, as I said in evidence in chief, is that based on the elements affecting this development, namely the quantity of units being proposed versus the amount of open space required in order to mitigate against the bat habitat, the inspector can be confident that the scheme that comes forward at reserve matters will be similar to that is on the table at the moment. And that is why the inspector, in my opinion, should take confidence from the fact that we are saying approximately 44.13%. As I also said, it is commonplace now that councils are considering biodiversity net gain to be achieved as part of outline applications. And therefore, I would find it incredible if all future applications that this council considers, they're just going to turn around and say, we're not going to deal with B&G because you're an outline application.
Well, I'd find it
Unless that's
incredible
going
too.
on the
If that was our approach, I'd find it incredible too. It isn't. We see the reason I've taken the point, just to give you a chance to deal with it, then we're going to move on, is this. As I understood the way your case was put, you were suggesting that the particular figure that you say will be secured, although you don't have a scheme to secure it with, is to be accorded a certain level of weight by virtue of the quantum of the gain that you say can be achieved. Have I misunderstood your case? Because if I have, I can
No,
cheerfully move
that's
on.
correct. And I refer in the proof of evidence to the Secretary of State's Raynham decision, where effectively in that case, the Secretary of State considered a biodiversity net gain of 20% as worthy of being given substantial weight.
That's right.
So can I give you the reference number for that? Oh, sorry.
Well, I think we probably got it, but by all means do. That's why I'm asking the question.
Which document is it again? Which one? G45. Yep.
G45, that's right. So you see, the reason I'm pursuing this point
And
is...
are you referring me to a particular paragraph?
I'm referring you to paragraph 35 of the Secretary of State's decision letter, sir.
35.
Yes, where, as I said, 20% biodiversity net gain was considered to be attributed substantial weight.
Mr. Leader, do let him finish.
Sorry.
You know, it's not helpful to me to sort of rush the witness, please.
Right. Have you finished, Mr. Wakefield?
Sorry, 1 second. I just wanted to check that that was an outline application. I believe it was. So the Secretary of State saw fit to basically conclude on an outline application a 20% biodiversity net gain could be attributed substantial weight.
So, let us go to that together. Just give me the reference again. G45. Too many documents open. Right, so if we go to paragraph 35 of the Secretary of State's decision, and we look at IR 12204, we see, don't we, that just read 12204 to yourself.
I'm familiar with the paragraph.
And if you wouldn't mind, just have a particularly close look at the penultimate sentence.
Yes.
Do you see that one of the suggested conditions secures at least 20% biodiversity net gain?
Yes.
So, are you going to propose a condition which secures at least a 44% biodiversity net gain?
Well, we wouldn't need to do that, would we? Because
Well,
all I'm seeking to rely upon, all I'm seeking to do through the proof of evidence, and my evidence, is achieve a substantial weight. So, in order for this inspector to give the biodiversity net gain calculation or biodiversity net gain arising from this development substantial weight is to achieve a 20% biodiversity net gain improvement. So what we could do is we could effectively use that condition based on 20% net gain, and the inspector would have regard to that in the planning balance.
Well, that's interesting. Because you see, you referred us to this document, so we go to it. And before we went to it, you were talking about a 44.13% net gain. We then go to the document, we go past paragraph 35 of the Secretary of State's decision, and we look at what was actually the basis of what the Secretary of State decided, and we discover, because I'd read it, that there's a condition which was applied in that case, which secured the BNG, that allowed the Secretary of State to attach the weight he did. Now, when I put that to you, your reply is, well, we could have a condition in this case, which we could, but as I understood what you were saying just then, it's not a condition which secures 44.13%, it's a condition which secures 20%. Is that what you're suggesting?
Well, if the condition would have said achieve 44%, let's say, rounded down, if it was to say achieve 44%, then I would put it to the inspector that he may then be able to give that very substantial weight. All I'm seeking to do, as I said before in the proof of evidence, is to achieve substantial weight from this benefit. So if the condition was to say a minimum of 20% biodiversity net gain enhancement, that would, in my opinion, allow the inspector to attribute substantial weight to this benefit. Coupled with that, as I said before, I strongly consider that in the context of this scheme, based on the 2 points that I've raised, I believe that a much greater than 20% biodiversity net gain achievement could be made from a future reserve matters application.
Well, be careful, because I thought what you'd done was you'd adopted Mr. Farmer's evidence. You don't actually know, do you? Mr. Farmer's the chap who's given the evidence on this point, or rather put in the relevant documents. So you don't know whether 44% is especially achievable or not, but what you're doing is you're adopting Mr. Farmer's evidence, aren't you?
I'm adopting his evidence as part of the reference I make to 44%.
Yes. Now, so just to be clear, because you took us here, so I think I'm entitled to finish this off. We can see, can't we, that in this case the condition was attached, and in this particular case, and I'm going to deal with this particularity point in a moment, the Secretary of State concludes 20% attracts substantial weight. What I want to understand is what is, to help my learned friend, going to be his closing submissions. Is it going to be that we will be asking this inspector to conclude 44% can be secured and we'll ask for a condition? Or is it going to be at least 20% and we're going to ask for a condition? What's it to be, please?
I would offer Mr. Garvey the position that we will be putting forward a condition offering a minimum of 20% biodiversity net gain, which should then be attributed substantial weight in the planning balance.
Right.
And I would add to that, and maybe Mr. Garvey will include it in his closings or otherwise, he is far better equipped to make that decision than I am, to say that the inspector would be able to then take into consideration the other 2 points that I've mentioned that I won't repeat, that effectively see no reason why a future reserve matters application could not achieve a biodiversity net gain much greater than the minimum 20%.
Yeah.
But still only attributes substantial weight to it, because that would be fair and reasonable.
But you're asking for 20%. Now, the last question then is this. You will appreciate that Secretary of State decisions, any inspector's decision, is determined on its own particular facts. Yes?
Yes.
So, you would accept, wouldn't you, that what was considered to deserve substantial weight in the particular facts of the case we're dealing with might or might not deserve to be awarded substantial weight in other cases? It's all very fact-specific, isn't it?
2 points in response to that. Firstly, there is nothing in the decision to suggest there was any special circumstances affecting the 20%. And second point is the Council's putting forward no evidence whatsoever to contest the calculation being made, which provides at least 44%. So I see no reason why 20% can't be considered.
Well, we've dealt with why the Council didn't put in any evidence and why our ecologist hasn't dealt with this. I'm not going to go over that again. So you're, I think what you're doing is you're agreeing with me. You're saying, yes, every case is decided on its own merits, and you're not able to point to any paragraph of this inspector's decision which helps us understand why 20% was given the weight it was in this case.
That was not my answer, sir.
No, but if you can help me, help me.
Sorry?
If you can help me, help me.
Well, I've already helped you by giving you an answer to your question, which was along the lines that there is nothing in the decision itself to suggest there was any special circumstances surrounding the 20% in its calculation. That's my first point. And the second point was the council put forward no information to contest the 44% calculation that has been put forward before the inquiry.
Well, then go to page 191 of the decision G45, back to 12204, and let's see if we can find a reason why the net biodiversity gain of 20% might have been given substantial weight in this case.
Sorry, I will do that, I promise you, and sorry to interrupt you, but I will add this, that in that decision, the ecologist advising on this particular matter was a Tim Goodwin,
Right.
of Ecology Solutions. Mr. Goodwin is Mr. Farmer's colleague, and in conversation with Mr. Farmer, he did advise that clearly, based on his calculation, there is no reason why the net gain being prescribed here, i.e. in this appeal decision, could not be effectively equated to the appeal proposal before you now.
I'm not sure I really understood all of that. So first of all, is any of this written down in your evidence anywhere?
No, it's not.
No.
But
So I just wanted to know that. Good.
Right, had you finished, Mr. Wakefield?
I hadn't, but at the time we didn't know that this
don't-
issue was being contested anyway, so
Can
why
you just,
would it?
can you just
I'm
not-
sorry, sir, I thought he'd finished, so
yeah,
I apologise.
maybe need to take a short pause before.
Yeah. But, sir, forgive me, if I may, I think what I'm entitled to do is ask for answers to my questions.
Yes, without a doubt, but there's been a few moments where you've started a further question before Mr. Wakefield's finished speaking, and that's not helpful to me.
All right, sir.
Had you finished, Mr. Wakefield?
Oh, to be honest with you, I've lost my flow, sir, so I'll let Mr. Leader carry
Well, no,
on.
what I asked you to do, you see, was just I asked you whether it had been written down anywhere. You said no, which is why I thought you'd finished the answer. But then if there's something you want to add, by all means do.
I will add that at the time that we provided the evidence, that there was nothing from the council to contest what we were saying. So it wasn't felt necessary to actually go on to that point or to address that point.
Yeah. Now, the point that you wanted to go on to address was that there was a conversation had by Mr. Farmer with somebody who was called Tim. What was his name?
Tim Goodwin.
Tim Goodwin. Right.
Tim Goodwin is the partner at Ecology Solutions alongside Mr. Farmer.
Yeah. So this partner of Ecology Solutions alongside Mr. Farmer has a conversation with Mr. Farmer.
And then with me, and the outcome of that conversation is that there is nothing material between the two schemes that would prevent or cloud the ability for a 20% biodiversity net gain concluded in the Rainham appeal being given substantial weight in this appeal. There were no special circumstances between the two that would cloud the 20% being given substantial weight.
So the ecologist, Mr. Goodwin, tells Mr. Farmer the 20% substantial weight in the decision at Pump Lane in Kent is comparable to the situation at Churchill. Is that what you're saying?
In terms of the weight to be given, there were no distinguishing features between the two sites that meant that, substantial weight in Rainham would mean effectively less weight at Churchill.
Yeah. Okay, good. Well, that's where I was going before we had that digression. So go to 12204, please, on page 191. No distinguishing features. The current use of the appeal site as a commercial orchards includes a spraying and fertilisation regime that suppresses biodiversity on site. You don't think that's perhaps a bit different to the situation we're dealing with?
To be fair, you're now starting to go into some technical points that might affect the actual calculation. All I've done is effectively given you a broad point around the calculation and what weight could be attributed to this scheme versus the Raynham scheme. You're now starting to address points of technical points on the context relevant to those sites and how the calculation might be made. I just don't think that's reasonable.
Well,
I'm not trying to dodge the question. I'm not the ecologist. I can't answer questions around context of those sites and how they will then impact on the biodiversity net gain calculation.
my last point is going to be this. What you're experiencing is council doing their job, because you said there were no distinguishing features. You then gave me a record of a conversation that you'd had with a Mr. Goodwin and Mr. Farmer.
No, I had it with
Hang
Mr.
on,
Farmer.
now let me
Sorry.
finish my
Sorry,
question.
apologies.
Okay? You then gave me the conversation, the record of the conversation, and I made a note there were no distinguishing features that would have allowed the particular approach at Pump Lane to be, well, disapplied in this particular case. So what I've taken you to, you see, is paragraph 12204 and suggested to you that when one reads the plain words there might well be distinguishing features. We just don't know yet, do we? And you're right, you're not an ecologist, but those were your words, no distinguishing features. What I'm putting to you is this, and this will be the last point on this topic, which has taken a bit longer than I thought it would. There might be distinguishing features, there might not. As you say, you're not an ecologist, you don't know, and we await to see, don't we, how much BNG can be generated, and then to decide how much weight can be given to it. That's the last question on the topic. Do you want to answer it?
Well, we know what could be achieved because we've given the calculation to show what can be achieved. And irrespective of characteristics, context, etc., in my opinion, a 20% biodiversity net gain, a condition that seeks to achieve a minimum of that in this case, should still be given substantial weight, as it was in that case.
Right, good. Well, I think we've had that one enough. We can make submissions on that. Would you give me a moment? So that might be all I need to ask. No, there's one last topic. I don't think this will be too contentious. If you'd like to put G45 away and go to G44, which is the Hallam Land Management decision. Right. Now then, I think you were taken, or you took us, to Lord Justice Davis's short judgment, and in particular paragraph 82. Would you like to go there?
I have that.
Now, do you see just above Lord Justice Davis's heading, the Lord Justice Davis in bold, there's a Lord Justice Hickenbottom who says, for the reasons given by Limblom LJ, with which I entirely agree, I agree that the appeal is allowed on the first issue alone. Yeah, do you see that?
I do.
One of the things Lord Justice Hickenbottom doesn't do is agree with the reasons given by Lord Justice Davis, does he?
You're not cross-examining about the rules of the Court of Appeals judges and the impact of that.
Well, no, the reason for that will become apparent in a minute. So if we could just go, please, into Lord Justice Limblom's decision at paragraph 48. We'll go there first. Just read that paragraph to yourself, and when you've read it, let me know. It's quite a short one.
Just 48, or do I need
Yeah,
to
just
read
48
the
for the
context to it as well?
I'll take you elsewhere in a minute, but if you'd like to read 48 yourself.
I've read 48.
Yeah. So there's the principle set out by Lord Justice Limblom. You're not going to disagree with it, are you?
No, so I think what Lord Justice Limblom is saying there is, or dealing with there, is the application of paragraph 14 of the framework. Obviously, Lord Justice Davis is dealing with the matter of weight to be given in the context of the shortfall. So I believe those are two separate matters, are they not?
Well, that's so, but if you'll forgive me for saying so, that's not the question I asked you. So you're very welcome to try and anticipate my questions, and you may be right, but I think I've asked you a straightforward question, you give me a straightforward answer, you don't disagree with the proposition put there by Lord Justice Limblom. So let us go back to Lord Justice Davis's decision. If we look at paragraph 82, why are we troubling ourselves with the shortfall? It's not necessarily itself, that is the shortfall, which will be the key consideration. But to read the last sentence of 82, ordinarily it will be relevant and material, sorry, it will be irrelevant and material consideration requiring to be evaluated. And then we go to 83, and that's because the amount of any shortfall bears on the weight to be given to the benefits or disbenefits of the proposed development. That's the point, isn't it? It's not the shortfall per se, it is the weight one gives to other considerations.
Dependent upon the shortfall, yes.
Yeah. And the weight one gives to other considerations and the way in which it's affected by the shortfall will depend, won't it, amongst other things, on the harm that is caused those other considerations and their importance.
No, I believe you look at the shortfall and then that affects the weight to be given to the harm. I think what you suggested was the other way round. You identify the shortfall, the extent of the shortfall, the persistency, etc., and then that informs the weight to be given to, in this case, the disbenefits or the benefits. That's the correct approach, in my opinion, based on the Hallam-Van judgment.
I'm not sure we're disagreeing, actually. All I'm suggesting to you is taking concrete examples in this case. We have landscape impact and impact on designated heritage assets, don't we, as the local planning authority's principal objections to the scheme.
Yes.
And Mr. Etchells, to take landscape as an example, ascribes a certain importance to the value of the landscape that's affected, its visual impact, and also the impact on the ONB. And Mr. Cook takes a contrary view. But the point is really this, that if the inspector shares Mr. Etchells' view on the landscape character of the site, the visual impact of the scheme, and sensitivity of the site, then he's entitled, isn't he, to find that those considerations ought to prevail, notwithstanding the absence of a 5-year supply.
Still prevail, but the weight to be given to them would be affected by the extent of the shortfall. So, for example, if the inspector agrees with Mr. Tiley, roughly speaking, and says 3 years as opposed to, let's say, 4.5 years, I would put it to the inspector that he would then be in a position where he could give less weight to that adverse impact in the context of the 3-year conclusion as opposed to the 4.5-year conclusion.
Possibly, but then go to paragraph 51 and we'll finish this topic on paragraph 51. Because you see, where we've got to, I think, is this. First of all, that there's no requirement in law to come to an exact measure of the 5-year supply. Second, to observe that it's not necessarily the amount of a shortfall per se that matters, it's the way it impacts on other matters. And then the third point is, in looking at the weight one gives to a shortfall, one has regard to what's said at paragraph 51. Now, this is where I'd like to finish, and I'd like to do it like this. Broad magnitude of shortfall is something the inspector is going to decide for himself, because we've had the 5-year housing land supply discussion. How long it is likely to persist next, though? You'd agree with me, wouldn't you, that the local development scheme produced for the draft local plan sets out the timetable for the production of that plan?
Yes, it does.
And you've looked at it, no doubt?
Yes, it says anticipated adoption in December 2023, I believe.
Yes. And you'd agree with me that at the moment the council is on track in accordance with the timetable specified by the LDS.
Well, the LDS has only just been prepared, hasn't it? Or updated?
Well, I'm asking you the questions if you don't mind.
Well, that's
If you
my,
don't-
that's
if-
my,
again, if
that's
you-
my understanding, is that the LDS has only just been published, so it would be very difficult to not be in accordance with it.
Well, that wasn't the question with respect. The question was, having looked at it, has the council so far, put it another way, departed from it? It's a simple question.
Okay, it hasn't, but as I said, it's only just been published, so it would be difficult for it not to be in accordance with it.
When you say it's only just been published, when was it published?
Is anybody able to...
Well, no, they're not able to help you. You said it's only just been published.
Again, you know, I'm not sure how much it's going to help me, whether...
Well, sir, if you'll forgive me, I appreciate that certain elements, my approach to some extent irks, and I apologise for that, but if the witness says something that begs a follow-up question, I think it's up to him to tell me. I thought he knew the answer when he answered the question.
Yeah.
I mean, what are you doing? Are you going on the internet?
I'm trying to find on the internet when the local development scheme was actually released.
That's not appropriate, frankly, during cross-examination. If you just say you don't know, it's probably the better thing to do.
I don't know.
Right. Thank you. So when you say it's only just been published, the truth is you don't know whether it has been, and you're checking on the internet to find out the answer. That's fine, but if you'll forgive me for saying so, that's not a proper approach to cross-examination. I'm surprised you didn't know that. All right. Finally then, the question as to how long the shortfall is likely to persist will turn, won't it, on how fast the local plan is produced and adopted.
Is that a question?
Yes.
Can you repeat the question, sorry?
Yes. The question of how long the current shortfall will persist is likely to be affected, isn't it, by how fast the local plan is adopted. Because when the local plan is adopted, it will have to be sound, and to be sound, there will have to be a 5-year supply. That's right, isn't it?
Yes.
So if we proceed on the basis, the local plan will be adopted in accordance with the LDS, I think it's your evidence that the plan will be adopted in 19 months.
That it will be adopted in 19 months?
Yes.
No, that's not my evidence.
Well, I thought it was your evidence, and if I'm wrong, I'm wrong.
I say that the plan will be likely adopted in a considerable period of time from now. And you heard in evidence in examination in chief that effectively I raise a number of factors that will affect the adoption of the plan. And as I said in evidence in chief, those are all considerations which to my mind support my conclusion that it will certainly not be 19 months until the plan is adopted. I can go through those factors again if you'd like me to.
Well, I'd rather you answered my question, because you'll have noticed I had a way of putting it which required you to form a answer on the basis of an assumption that I put to you. So I'll repeat the question. If you wouldn't mind just answering my question rather than one you'd like to answer, it was this. Assuming, and which is what I said, assuming the local plan is produced in accordance with the LDS, I think it's your evidence that it will be delivered in 19 months, because I think the LDS, you said earlier, indicates the plan would be adopted in December 2023. I thought that's what you'd said. Am I wrong?
Yes, I think that's what it says. I think that's what it says in the Statement of Common Ground as well.
Yes. Yes, good. So assuming that the LDS is right, and I appreciate you say, oh, well, I don't think it's going to be right, and you did give us a whole pile of reasons for that, but assuming it is right, there will be, won't there, a 5-year supply in about 19 months' time.
If that is correct, then yes, there will be a 5-year housing land supply in that period of time.
Yes.
If that is a very, very big if.
Well, we have agreed, I think, that the LDS is on track. So on that basis, it leaves me to say thank you very much, and the cross-examination is completed. Thank you, sir.
Sorry, can I just caveat? I didn't say that the LDS was on track per se. I did not say that the LDF. I said that it would be effectively, your question around the LDS is relevant to the adoption of the new plan, and I'm saying the new plan will not be adopted for a considerable period of time. Just so that my answer is clear.
Well, just to finish things off, I think, to be fair to me, and I'm not often fair to myself, but I'll try it once, I put it to you that the LDS is on track, and I think your answer was along the lines of, well, it's only just been published, and then I said, when's it been published? And you said, well, I don't know.
Well,
I'm right, aren't I, that you don't yet know of anything which indicates the LDS isn't on track?
Admittedly, given I don't know when it was published, I would, sir, take any answer on that from myself with a big caveat. I think the more important point is I say that the new plan will not be adopted for a considerable period of time.
Yes. Thank you very much, sir.
Thank you. Thank you, Mr. Wakefield. Short break, short adjournment, or have you got much to?
Have any issues on re-examination, but just on that last point, I can tell you the date of when this was published.
Well, I don't think I need to be told.
Very well, sir. In that case, I've got no re-examination, sir.
I've got no questions, Mr. Wakefield, either, so
Thank you, sir.
thank you very much. Right, is there anything else that anyone wishes to bring to my attention? No? Have we abruptly nearly come to the end of this day? Feels as though it was quite abrupt sort of end to it.
We could keep going, I suppose, if you wanted us to, sir.
No, I'm not encouraging that. Okay.
But so what I ought to do is just remind you, if you'll forgive me, that tomorrow morning between 9:30 and 10:30 I've got to do a remote court hearing, but I've told the judge I have to be free by 10:30. I suspect I don't, actually, because it's conditions, isn't it? And they're not scheduled to finish, I think, until about lunchtime. But
Yeah.
So if it does accidentally run on a bit, those who instruct me are coming along with the relevant experts to talk to you about conditions. I don't think you need counsel in attendance anyway. I know my learner friend's going to be here, and we discussed it, and I'm very relaxed about that on the basis that probably won't involve legal submissions, and if it does, I can pick them up when I get back.
No, I'm not going to have that much that I want to raise about the conditions anyway. If it helps you to know that, there'll be a few things to discuss, but not. It's not going to be anything that's of massive surprise or a great deal of contention, I don't think. Obviously, I'm not being held to that should I discover something overnight, but that's my view as I sit here now.
Just on conditions, sir, we would have to put in that condition which Mr. Wakefield advanced from the Raynham decision. It's condition 12 from that, but we can address that tomorrow. But just
Yeah, we'll talk about it tomorrow. If you propose to do that, you should come with the wording that you wish to put forward. It will be helpful if the council have seen that sort of in advance as well. Okay. So has everybody signed the attendance sheet? Yeah. I will ask, is it still the case that we're not expecting any cost applications? Okay. And then tomorrow you'll have those finalised sort of itineraries and that extra plan that I asked for Western Villages? Yeah? Okay. So, on that basis then, so tomorrow we'll come back, we'll do the roundtable session on conditions first, followed by the planning obligations. Then we'll hear the closing submissions from both sides, hopefully. You'll have those for me in writing, presumably. Yeah. Okay, and then hopefully we'll be able to deal with any cost applications if there are any, site visits, and hopefully close the inquiry tomorrow. So, with that said, we'll adjourn for the day, and we'll come back at 9:30 tomorrow morning.
The only question I was going to ask you, sir, is do you have a preference as to how detailed closing should be? Some of your colleagues expressed fairly strong views that there shouldn't be more than about half an hour. To say about half an hour is the indication I've often been given, and I just wondered whether you have a view on that.
No, I mean that's usually what I would expect, not limited to. If there was specific points that you want to deal with in them, you know, I'm not very strict in that regard. But obviously I don't want to be sitting here for hours hearing detailed submissions, rehearsing every point that we've been over. It's not going to help me.
I stick to the key points, sir, so 30 to 40 minutes is normally always where I hit it.
Don't feel limited, but yeah, that would seem reasonable.
On judgment, sir, I don't envisage putting in many. There is only one legal point, and it's I'll put it in, but it just says that the MPPF is consistent with the Listed Building Act. So there's an authority called Hackney, which I'll supply to my learned friend, which makes that point. But I don't envisage putting in anything else, as we say here today.
Okay, and is that the same for you, Mr. Leader?
Yes, you're not going to be helped by lots of authorities that you know well. I was going to put in Monk Hill, but you'll know Monk Hill, sir, I think. Tells you how to apply the tilted balance. You don't need us to tell you that.
Yep.
So no. I was going to put in King's Lynn as well, but again, I think it's a tangential point.
Yep.
I'm not sure what my own friend's point is, but you can tell me afterwards.
All right.
That's all right.
Okay. Well, obviously, if you do decide between now and tomorrow, again, it's not going to be too helpful to me to receive many judgments, but if there are key ones that you want to put in, you're not limited, but obviously I do want copies be handed to me, if that's okay. Okay. Anything else? All right. So 4:15, we'll adjourn until 9:30 to tomorrow morning.